everyone, my name is Al Parsai. I'm a regulated Canadian immigration consultant. I also teach immigration consulting at Ashton College. I'm the author of the book called 88 Tips on Immigration to Canada, which often is the bestseller on Amazon.ca, and you can find it anywhere on Amazon websites. Today, I would like to talk about a relatively dark topic, which is removal orders. Sometimes everything doesn't go well, and a person who is already inside Canada receives a removal order. That could be based on inadmissibility to Canada and anything that falls under sections 33 to 43 of the Immigration Act. If you receive a removal order, you don't need to panic immediately, because some of the removal orders, they are not enforceable. That means that you receive the removal order, but the officers cannot enforce it. They cannot remove you from Canada. For example, because you have filed for judicial review, or maybe because you have filed for pre-risk removal assessment, or maybe because you have filed for humanitarian and compassionate considerations and you have passed the first stage. So that's important to know whether your removal order is enforceable or not enforceable. But regardless of enforceable or unenforceable removal order, we have three kinds of removal orders. The first one is called a departure order, which is probably the least bad removal order. It means that you need to leave Canada, but if you leave Canada in less than 30 days from the day that the departure order becomes enforceable, and you also report your exit from Canada to the Border Services authorities, then you are not banned from going back to Canada because of that removal order. Obviously, you need to meet the requirements of the Act and regulations to come back to Canada, but this removal order on its own doesn't impose any sanctions to you in terms of coming back to Canada. So that's departure order. The second group is an exclusion order. By default, an exclusion order prevents you from going back to Canada for a period of 12 months. If the exclusion order is created or issued based on misrepresentation, then the ban is 60 months or 5 years. If you want to come back to Canada in less than 12 months for a regular exclusion order or 60 months for a misrepresentation exclusion order, then you need to apply for something called an ARC, or Authorization to Return to Canada, before even you can go back to Canada. The third group of removal orders is called a deportation order. A deportation order bans you from entering Canada forever unless you apply for an authorization to return to Canada. Unless you do that and you receive a positive ARC, you cannot come back to Canada ever. Now, if somebody receives a departure order and they don't report their departure from Canada, or they don't leave Canada within those 30 days limit, unfortunately, their departure order will automatically turn into a deportation order. And by the way, if somebody receives an enforceable removal order and they do not comply, then Canada Border Services Agency may issue a nationwide warrant for that person, and any police force in Canada could arrest that person and facilitate the removal from Canada. I hope you never encounter any removal orders, and regardless, I hope you enjoyed this dark video. Thank you.